Good afternoon, everyone, and welcome to ATSSA's webinar on leveling the playing field for contractual liability. My name is Donna Clark, and I will be managing today's webinar on the back end. Your moderator for today is Todd Welch of Charter Partners, Inc. Today's webinar will be 60 minutes in length, including time at the end for questions. We ask that you keep your line muted during the webinar unless you are speaking. If during the webinar you have a question or a comment, we ask that you utilize the Q&A feature. At this time, I would like to read a disclaimer, and it is as follows. Information provided during this webinar is not legal advice. Rather, all information, content, and references are for general informational purposes only. I would now like to turn the webinar over to Todd. Todd, take it away.
Thank you, Donna. I first want to welcome everybody. I understand this is one of the best attended webinars we've had at ATSSA in a long time, so thank you for coming. My name is Todd Welch, and I'll be your facilitator. I want to acknowledge Donna and her team. There has been an outstanding effort on ATSSA side. There's a lot of work that goes into putting these webinars on, and they've done a great job. We're talking about indemnity here, and I want to tell you how we got this started. We actually, there was a meeting held in Tampa at the last ATSSA Expo, and we were forming an insurance company. Our goal, what we do for as a company at Charter Partners, is form insurance companies, and we were trying to put together an insurance company for ATSSA. We're continuing to do it. We hope to announce the insurance company this year at the ATSSA meeting in Phoenix. But the more interesting thing that happened was at the end of the meeting, Donna came to me and said, you know, Todd, there's something related here that we think might be of interest to you on this insurance project. And we have an email from Whitney Remis, who said that she has a concern. She sees something, she's an attorney for RoadSafe, and she sees something nationwide that maybe the rest of us don't see. It's a bit of a harbinger. And what she said was there was liability being pushed down consistently around the country from the prime contractors to the subs that was a real cause for concern around insurance and liability and things that really might be difficult for our contractors. And so we started exploring that, and we put together a team. We actually shifted a lot of our energy over to that focus. We said, no sense forming an insurance company if it's not going to be profitable. And so we started working towards this idea, and this team formed, and there's 5 of those members here. There's about 12 altogether, but 5 of those members are here. And we thought it would be really interesting if, you know, and helpful to you, if we could first identify the issue that we were seeing, and then look at it from 5 different perspectives. And then in a pretty brief period of time, maybe give you some tools, techniques, and ideas to help you combat this issue. So that's how we're going to do that. We're going to, the 5 different perspectives are the contractor's perspective. We're going to introduce Doug Dolinar here in a second, but also the scope of work and indemnification perspective. We're going to look at an attorney view, an insurance company view, a risk manager view, and hopefully all of that will give you a really good sense for the problem and also the solution. So let me first start by introducing Doug Dolinar. He's our first panelist. I've known Doug for a long time. His bio's here. We're going to send this to you, so you're going to see this document after the meeting's over. But I want to introduce Doug from a personal perspective. I've known him for a long time. He's pretty famous at ATSSA. I think his name was mentioned 4 or 5 times on just at this general session last year. But what's interesting to me about Doug's work is that he's really passionate about his workers, so much so that I saw him over a number of years develop technology. He's a line striper, so he developed technology to put basically a GPS system on the back of a truck that allows a truck to be like a Tesla and paint a line. And the purpose of that was, although the technology is cool, was to get his people off the road. And it's called LimTech. You should check it out. But the second thing that I noticed about Doug over the years is how serious he is about integrity. He doesn't like when someone's pushing, you know, liability down on him. He wants to make sure that, you know, it's fair. And I've seen him work hard over the years to you know, level the playing field. And that's why he's our first speaker. He's going to give us the contractor's perspective on leveling the playing field. Thanks for being here, Doug. You're on mute, Doug. I'm going to put you, yep, there you go. Thank you.
Thank you. Thank you, Todd. Very, very kind words. Appreciate it very much. Thanks. Yeah, I'm Doug Dolinar, president of Guidemark. Guidemark's a line striping company. We've been in business for 42 plus years. So my expertise is in line striping. I know a little bit about maintenance and protection of traffic. And I know even less about insurance, or at least before I knew very little about insurance, but I've learned a lot since being in business. But as a subcontractor on these big construction projects, you know, we bid the job to make money. We bid it to protect ourselves. You know, we do some negotiating with our customers, the prime contractors, and then, you know, we're happy to get to work. We feel confident. We are experts in our field, whether it's line striping, guide rail, or traffic control, and we've done this work 1,000 times. So we get the subcontract agreement, we sign it. We need to send in insurance certs, no problem. We pay for insurance, so we're good to go. Notice the blue skies and fluffy clouds behind the trucks there. Advance, please. But claims happen on all these projects. Stuff just happens, and you're on a job doing your thing, and all of a sudden, through some negligent act or careless act or a really negligent act, let's say, prime contractor, superintendent, drunk on the job, and he runs into the back of your truck. Let's say he kills 2 of your workers. You know, unbelievably horrible things can happen out there. We've all heard of them. But let's say in this case, one of your workers is a father of 2 and his wife at home's pregnant. You know, so there's an investigation going to happen now. You know, who's at fault? Of course, certainly not. It's not my fault. I didn't have anything to do with it. But again, somebody's going to pay. And again, my thinking is, well, not me. Again, it's not my fault. So this is where the investigation begins. This is where the insurance company comes online, and they're here to protect you. Advance, please. So now the conversation starts between you and the prime contractor that you have the subcontract agreement with. And the prime contractor, you know, he can admit to you, yeah, it's my fault, but you're still paying for it. And of course, you or me, you know, it's why I didn't have anything to do with it. Because, advance, please. Because you agreed to insure the prime contractor for their sole negligence. It was in the contract. You know, the contract that tells you, here it is, look at it. Now, advance, please. So we look at our subcontract agreement, and buried in all that small print are these words where the owner and the prime contractor are included as additional insureds, even for claims regarding their sole negligence. So buried there in that paragraph, and who knows, it's probably on page 64 of a subcontract agreement, is this simple little sentence. This simple little sentence, you know, can bury you. But like a you know, I'm a line striper. I bid the job to do line striping. I know what the costs are. I know what I bid for. You know, I know what the bid to get the job, and that's my expertise. I'm not an expert in language like this. Well, first of all, you got to look for it. You know, you got to find it. I'm more worried about what I'll call the important stuff, the pricing in that, or the traffic control. But these sentences, these little blurbs are in there, and we need to look for them. And again, then it's not a big deal here until it becomes a big deal. And you're going to learn a lot about it when you get drawn into a lawsuit. Advance, please. So here you are, you find yourself in a courtroom. It's certainly a foreign environment. You know, we're not used to working, you know, we're outside all the time. We're not used to working inside a courtroom like this. And trust me, there are no blue skies or fluffy clouds in a courtroom. Advance, please. So you're in the courtroom. The attorney that's being paid by your insurance company is trying to defend you. And trust me, when you're in that courtroom, your good relationships with your customer, they're right out the window. The people that you deal with very likely are not in that courtroom, but other representatives of the prime contractor are. And trust me, they're not your friends when you're in that courtroom. Advance, please. So you could have the best attorney in the world. But if you've agreed to insure somebody for their sole negligence, you've sent your attorney into a gunfight with his hands tied behind his back. You signed a contract. Now the insurance company and the attorneys are doing their very best to protect you. Advance, please. So let's say the jury awards $20 million to this family because their father was killed, your employee was killed. Let's say you have $5 million insurance. So the insurance company, okay, they're going to pay the $5 million. You're going to come up with the next $15 million. And I'm sure there's very few people that can come up with $15 million. So yeah, it's a shame you lost everything you worked for. Advance, please. So it doesn't need to be that way. The insurance is there to protect you, but you can help protect yourself by helping the insurance company. So a little basic understanding goes a long ways. Look for those words like hold harmless, sole negligence, or solely partially responsible. Advance. And the prime contractors, some of them are going to try and transfer their risk, and it's unfair. So take the time to read and understand the contract. When I read a contract for the first time, I use a ruler. I read every word. If you need help, ask your broker, ask your attorney, and don't be afraid to say things like, this is not fair. This is not fair for me to insure you for your sole negligence. Again, I've used this. What if your superintendent is drunk and wholly responsible? And another thing, I'll agree to indemnify the state, the agency, the owner, to the same level that the prime must indemnify the state or the owner. But I will not indemnify the prime. The reason being, the prime has a lot of workers on a job. It's the people that will be involved in claims, whereas the state or the owner has a couple people on a job. Some inspectors, just a handful, but nothing like the prime or yourself. But remember, you do have the authority to negotiate your contract in this wording. And keep in mind, your authority trumps the authority of the prime representative you're dealing with. Your authority trumps an attorney's authority, a broker's authority. You're the business owner, or you're representing your business. You're paying the bills. It's your company. Don't put your company at risk unnecessarily. Thank you.
Thank you very much, Doug. Okay, our next panelist is Whitney Remes. And Whitney, as I've already introduced, she has given us the legal perspective. And what I love about her perspective is that it has a national view, and she's seen, changes all around the country where it's working, where it's not working. First person to alert us to this. And Whitney, thank you so much for being here. Could you please share your thoughts?
Thanks, Todd. My name is Whitney Remes. I am in-house counsel for a national traffic safety services provider. While I can't give you legal advice, I do have a unique perspective to share with you on the interplay between contracts, indemnity and insurance, and job site safety. It's no secret that we live in an overly litigious society. I stubbed my toe, I'm going to sue. I slipped on a banana peel, I'm going to sue. I drove into a tree while texting, I'm going to sue. As we all know, the single greatest threat to work zone safety is distracted, fatigued, and impaired drivers. When not entirely focused on the work zone, motorists miss the signs, the warnings, the mergers, the shifts, and of course, the big, bright, blinking traffic safety devices. When these things are missed, accidents happen. People are killed and seriously injured, not only workers, but the traveling public as well. Because of the world we live in, and due to the nature of our work, lawsuits are simply inevitable. So in order to protect the business, a strong casualty insurance program should be in place, and subcontractors need to advocate for themselves via contract language negotiations. Advance, please. Make no mistake, owners and general contractors seek to continually develop strategies to transfer the entire risk of work zone vehicular accidents to subs and suppliers through their contracts and insurance requirements. Stratospheric jury verdicts and rising costs of litigation are only further increasing these efforts of upstream entities to shift the entire burden of risk downstream. Contractors approach subs with a take it or leave it attitude, oftentimes attempting to force subs to sign agreements containing language that may not be permissible in the jurisdiction where the work is being performed. Interestingly enough, as Doug pointed out, When confronted with a statute or law that provides that the proposed contractual language is or may be impermissible, oftentimes contractors change their tune and will agree to modify the language to fall within the purview of the applicable law. Risk transfer is achieved through indemnity and additional insured provisions. An indemnification provision will typically say something along these lines. To the fullest extent permitted by law, the subcontractor shall indemnify, defend, and hold harmless the contractor from and against all claims, damages, losses, and expenses, including attorney's fees, arising out of or resulting from the performance of the work, whether or not such claim, damage, loss, or expense is caused in whole or in part by the owner or contractor. In short, both the owners and the contractor's fault for the accident will be completely dropped at the feet of the subcontractor. In passing anti-indemnity statutes, some states and courts have recognized both the unfairness of certain risk shifting efforts, but also the detrimental effect it has on the safety of the work site. Courts have actually ruled that anti-indemnity statutes increase safety at work sites because it encourages everybody to be safe. When a subcontractor is indemnifying a contractor for its own negligence, this actually reduces the general contractor's incentive to maintain worker safety, thus increasing the risks of accidents on or at the construction site. Advance, please. There are three types of indemnity agreements. The first one is limited. It's where the sub assumes only responsibility for its own negligence. This form is allowed in all states. The second is intermediate form indemnity. This is where the sub assumes responsibility for its sole or partial negligence. If the general contractor is solely at fault, then there is no indemnity. But if the sub is partially at fault, then the sub assumes full responsibility. What this means is that even if the contractor is 99% at fault and the sub is 1% at fault, the subcontractor can be forced to cover 100% of the claim. The third is broad form indemnity. This is where you're buying the whole farm. You're paying for your customer's negligence, regardless of the allegations or your involvement, and is the most onerous of indemnity clauses. Many states have enacted laws which basically say that you can't force another party to indemnify and defend you for your own negligence. However, a good portion of statutes only prohibit indemnification for the sole negligence of the contractor, which is that second one we talked about. Advance, please. In a handful of states, a subcontractor is only required to provide indemnification for its own fault, which is great. Unfortunately, there's a loophole you can drive a truck through: additional insured coverage. While legislators have worked to protect subs and other downstream entities from the effects of unjust attempts to transfer risk, many anti-indemnity statutes actually contain a carve-out that states that anti-indemnity statute doesn't or won't apply to a contractor agreement to procure insurance. Next slide, please. For example, see the Illinois anti-indemnity statute captioned on this slide. Down at the bottom, the highlighted text excludes agreements to provide insurance. So what ends up happening is, while the downstream entity may not have to assume contractual indemnity, their insurer is left footing the bill, whether or not the insured is actually negligent. This is a major problem for subcontractors because when an additional insured claim hits, it affects the subcontractor's insurance claims history and drives up insurance costs, which are already high due to the nature of our work. Most programs also contain significant deductibles in the 6 and 7 figure range. This often results in a subcontractor being forced to front significant attorney's fees and settlement costs before insurance coverage even kicks in to provide relief. Like in Doug's prior example, these are the type of bills that can put a small business's lights out. Advance, please. Let's go through a fictional example and see how it all works out. ABC General Contractor hires traffic sub to supply advanced warning signage to a state highway project. Traffic sub uses the plans provided by state and installs all required advanced warning signage. At some point following installation and approval of the setup by the project engineer, a work zone motor vehicle accident occurs. Motorist A is speeding and hits motorist B. Motorist B is seriously injured. Motorist A only has $5,000 automobile liability policy, and he tells the police he didn't see the reduced work zone speed limit. Motorist B then files a lawsuit against state ABC General Contractor and the traffic sub, claiming that the work zone signage was insufficient. State and ABC contractor then engaged in risk shifting efforts by tendering their claim to traffic sub because the lawsuit is related to traffic sub scope of work. Now you're probably asking yourself, how is this traffic sub's fault? They followed state's plans and the work was approved. The accident was caused by a speeding driver, not the signs, right? Well, depending on what the contract reads and where the law of the work was performed, traffic sub may end up being liable for this loss, including the defense costs and attorney's fees for both owner and ABC general contractor. Now, this particular scenario has a happy ending. Because the super savvy traffic sub negotiated the language, can you advance one, Donna? There we go. Because the traffic sub negotiated the language of the contract to limit its obligations to the extent of traffic sub's negligent acts or omissions. In doing so, traffic sub was able to protect itself and its casualty program from having to provide coverage to owner and ABC general contractor, leaving them to look to their own casualty programs for protection, which is how it should be. Next slide, please. Obviously, the ideal solution is for legislatures to draft anti-indemnification statutes that clearly prohibit subs from having to defend, indemnify, and insure any party for its own negligence. If a party is protected from its own negligence, there's no incentive for that party to be safe. Think about it. If a party is providing its own insurance, that party is responsible for paying any deductible and any increase in the premium that is associated with claims made against the policy. That party has an incentive to work carefully to avoid claims. On the other hand, if a party obtains insurance via an additional insured endorsement, that party does not have the same incentive. As some states lag behind in these types of legislative efforts, it's on subcontractors to protect themselves by being diligent with their contracts. Remember, the answer is always no if you don't ask. Next, Mary Beth is going to go over some contract modification examples with you. That's it for me. Thanks for listening.
Hey, great job, Whitney. Thanks for getting this all started for us. And so now we get to hear the perspective of somebody who actually has to negotiate these contracts every day with the prime, going toe to toe, head to head, and negotiating something, as Doug said, that's fair. So Mary Beth Applegate works with Doug, and she is a paralegal, and she's going to share with us what it's like to do this on a regular basis. Thank you, Mary Beth, for being here.
Thanks, Todd. As the contract administrator for Guidemark, I'm responsible for reviewing all the subcontracts that come through the company. A lot of subcontractors have no idea that they can negotiate their subcontracts before signing them. Negotiation usually starts by redlining or crossing out words or phrases in the subcontract. The general contractor can either accept or decline these changes. Sometimes the red line or crossed out words or phrases require further negotiation between the parties. Advance, please. Two of the paragraphs I make sure to focus on when I review a subcontract are the scope of work paragraph and the indemnification paragraph. The scope of work paragraph is one of the most important paragraphs in the subcontract. The scope of work is usually one of the first paragraphs of the subcontract. This paragraph should describe the details of the exact work the subcontractor is going to perform for the general contractor. This is often referenced as the quote, the work throughout the subcontract. It is important to make sure that your quote is referenced in this paragraph or attached to the subcontract. Should you be involved in a lawsuit, having your scope of work clearly defined will help in your defense. As an example, as Doug mentioned, Guidemark is a pavement marking contractor, and we were named in a lawsuit where a motorcycle driver was injured when he ran into a milled debris pile on the roadway. Since our scope of work was clearly defined in our subcontract and milling wasn't part of our scope of work, our attorney was able to have Guidemark dismissed from the lawsuit, thus saving the insurance carrier the litigation fees. And this is just one example. It's happened several times for us. Advance, please. Another important paragraph, which has been talked about already, is the indemnification paragraph. In its simplest form, indemnification is a contractual obligation of one party to compensate for the loss incurred by another party due to the acts of a third party or one's own actions. In other words, the indemnification clause addresses who will cover losses or damages to a party incurred or will incur due to a specific accident. Almost every subcontract contains an indemnification. Some indemnification Some indemnification can be contained in one paragraph, while some can span several pages. Advance, please. Prime contractors use the indemnification paragraph to attempt to transfer their risk to the subcontractors. They do this by using phrases such as in whole or in part, directly or indirectly, even for claims regarding their sole negligence, whether related to this agreement or any other agreement between the parties, and regardless of whether or not it is caused in part by contractors or a party indemnified hereunder. So lastly, to help you negotiate reviewing a subcontract, I have a couple suggestions. First, make a checklist of the items you want to review. Part of that checklist could include your scope of work, your price, your conditions, your insurance, indemnification, warranty, etc., depending on what type of work you do. Second, once you've reviewed a subcontract, copy it. That way, the next time you get a subcontract from the particular general contractor, you can just pull out the subcontract. You don't have to reinvent the wheel that you've already reviewed and complete it to the newest and compare it to the newest one you received. And then lastly, reach out to your broker about your insurance questions you may have. They're a wealth of knowledge and will help you negotiate and understand all the endorsements that the general contractor is requesting. Thank you, Donna.
Okay. Thank you, Mary Beth. Very well done. And now, so we're getting different perspectives, right? And now the next perspective, as Mary Beth just mentioned, is that, reach out to your insurance agent. That should be one of the first lines of defense. And hopefully they can help you with working through these contracts. One of the best people I've ever met to do that, honestly, is Mike Capel from Brown & Brown. He's like an engineer. He digs into these contracts deeply and knows them well, and is a great resource. So Mike, can you give us, welcome and thank you for being here. And can you give us the perspective of the insurance agent?
I sure can. Thank you, Todd. Good afternoon, and thank you to presenters, members, and visitors. I'm Mike Capel with Brown & Brown, global insurance brokerage and risk management firm, where we spend a considerable amount of our time reviewing and researching contract risk. Jumping right in, the next few slides will guide us through a general overview of additional insured and indemnification. Slide 1 is a very basic exhibit that illustrates the tiered structure of the contractual relationship. Each downstream party will be required to sign a contract. In the event of a claim based on this exhibit, we have an owner, 1 prime, 4 primary subs, and 2 additional layers with a total of 6 more players, giving us 11 different contracts that will potentially be examined. Advance. Some of the pieces that you will run into within the contract you just signed are types of insurance and the limits you are required to carry, along with additional insured requirements, hold harmless provision, indemnification provisions, there can be more than one, waiver of rights of recovery, aka waiver of subrogation, waiver of statutory immunity under workers' compensation. This is used for action over claims, and responsibility to comply with upper tier terms and conditions. Advance. We've all seen these items, but the question we need to answer is, what are we really doing when we add someone as an additional insured? You're providing direct access and rights to your policy. The additional insureds are entitled to defense and limits just as you are. So the question we ask ourselves is, why on earth would we hand out our limits of insurance? We pay for them to protect us. And of course, how do we do this? So we do it to meet contractual obligations. As Doug said in the beginning, we sign these contracts for the work, for the job, and for the revenue. We do this through an endorsement to the general liability, either specifically adding the other party or through an automatic grant of additional insured where required by contract. The other party will also want your insurance to respond first before theirs, and you've likely seen this referenced as primary and non-contributory. And finally, your broker will issue a certificate of insurance to serve as evidence of your compliance. Advance. It's important to note that we are all here to fight against the far-reaching contractual obligations, the obligations that shift the responsibility for sole negligence of another party. The insurance industry has also taken steps to distance itself from this position. This has been evidenced in the new wave of additional insured endorsements over the past 20 years. This is a hotly contested subject, and a widespread resolution to the issue is a long time coming. A few more notes is that it's important to always read the contract. The contracts are a moving target. I think all of the presenters up here probably can't say that enough. Protection is limited to the breadth of your policy. If your policy has restrictions, the additional insured is subject to those same restrictions. So the other party that you've added as an additional insured is subject to the same restrictions in your policy. This is important because where the additional insured falls short, you risk out-of-pocket expenses via indemnification. Additional insured is a simple request to your underwriter for both general liability and auto. It is readily available and a common request in just about every commercial contract. Advance. Moving into indemnification, quite often considered the counterpart to additional insured, and largely the reason we're all here. Number one, out of the gate, you're in this position because you have contractually bound yourself to it. You have agreed to make another party or parties whole from costs, expenses, claims, damages, etc. This is usually obligated for a number of parties, in my opinion, far too many parties, and usually for more than that which you would otherwise be responsible. An important distinction from additional insured is that the indemnity has no rights to your policy. The policy will include defense for that indemnity if you have agreed to it in a contract, but be aware that it does erode the available limit of insurance except in very limited circumstances. The CGL in its off-the-shelf format can respond to all forms of indemnification, as mentioned by Whitney, but keep in mind the indemnification provision does not consider insurance and therefore typically exceeds the availability of insurance. Finally, despite being known as counterparts, the indemnification stands independent of additional insured, so that providing additional insured protection does not satisfy indemnification. Advance. So the bottom line is that we want to limit the indemnification. The inequitable relationship is good for everyone. Seek to limit the indemnification to the extent caused by you or someone for whom you are legally responsible. Be mindful of how and to whom you are granting access to your policy and who you agree to indemnify. Keep within the scope of your work. Don't agree to dispose of waste on a site. Agree to dispose of your waste. Going back to Mary Beth's recent example. Be very careful because this is a real issue. Don't bet the business. The contracts can be and tend to be heavily lopsided in favor of the drafter. Take the time to review, identify any red flags, and request the changes. The complexity continues to fuel cost and concern. As we move toward a better contract risk environment, we can reduce the cost of risk associated with our members and across the industry. Try and focus on the 4 C's: clear, complete, concise, and consistency. And I think that importantly, the last item should simply be know your policy, review the contract, and work with your partners, whether it's a broker, an attorney, or a friend within the industry. This is a form of risk management and things will improve over time. Thank you, Todd.
Hey, great job, Mike. Thank you so much. We're about to introduce our final panelist. I would like our guests to maybe think about some questions they might have after Greg is finished. We're going to open it up and you can just type a question right into the chat area and we're going to answer your questions. But I want to introduce Greg Stefan from Arch Insurance. He is involved in risk management there. He's a highly requested speaker at ATSSA, and that's how we found him. He was speaking and we were very impressed with what he had to say, and we asked him to join our group, and he's been a great contributor. The only thing I would say about Greg before he starts is that I found working with him that we would often talk quite a bit, and he would kind of follow up at the end of the group's conversation with something that was profound and useful and that mattered. And so no pressure, Greg, but I'm glad to have you and looking forward to what you have to share with the group.
Right. Thanks, Todd. And I appreciate the opportunity to be here. So what I thought I would do to kind of wrap, the discussion up, obviously there's been a lot of ground covered, a lot of very important ground covered. And so I want to kind of level set and show you from an insurance carrier standpoint, kind of what we experience. So a little bit of my background. I've been at Arch Insurance for about 17 and a half years, another carrier prior to that. And the risk control department, what we do is we work with our policyholders when we are prospecting, when we're looking at quoting insurance on a potential, new customer. And then we're a consultative group, once we insure a group to try and manage risk and try and reduce the opportunity for a loss to happen because it's bad for both the carrier and it's bad for the policyholder. So this topic fits right in with a huge issue that we see play out in claims. So advance the slide. So I just want to, again, level set us. We're talking ultimately when things go wrong, we're talking about work zone related issues. And there's two huge severity components where we see the catastrophic losses happen from a claims standpoint. Now, the first one, which Doug mentioned and others have mentioned, is that we see a lot of highway, street and road utility workers that are injured and killed. There's a lot of activity, a lot of equipment, a lot of moving things in tight quarters. We see run over, back over accidents happen. So we see the fatalities and the serious injuries among the worker population. And where you start crossing from workers' compensation into other areas is when you have a public vehicle intrusion. A member of the public placed their vehicle where it was not designed to be placed on a roadway job. And so we have workers that are often struck by an errant vehicle that has come in and intruded in a work zone. What's also happened is that member of the public may have just been injured or killed themselves. So I'm not taking away from the worker safety standpoint, but everything we've talked about really comes into play with the next section here is public injury prevention. When a member of the traveling public is injured or hurt or something significant happens, there's going to be lawsuits that are filed. There's going to be litigation, and it's going to create a multitude of things that could happen with a multitude of entities. Advance, please. So when one of these horrible events happens, we're ultimately talking about general liability claims. To oversimplify a GL claim, it's when you could be one of any entities that's involved in a project. You've been alleged to have caused, or you've even contributed to damage to another party. And that damage comes in two forms. It's property damage and it's bodily injury. Now, when we're talking work zones, we're talking the nature of work that everyone on this call is involved in. We're not so much worried about the property damage. Property can be replaced, it can be fixed, it can be repaired. What we're worried about is damage to the occupants of those vehicles and those involving serious fatality or serious injuries and fatalities. That's where we see a ton of activity happening from general liability claims. Advance. So I do a lot of sessions on work zone liability, and I talk about this quite a bit. And this is a slide that I've used for 20 years. This is it wasn't a fatality. It was a serious head trauma, spinal injury accident that happened in an active work zone. There was a head-on collision that happened. And the reason I show this is you'll see the heading, a $6 million general liability claim. That $6 million took place 20 years ago. And $6 million is not a lot when we have a lot of bodily injury claims occur. It also took 5 years from the date of the accident for this claim to settle out of court for $6 million. So this is the type of event that we're talking about that stimulates a tremendous amount of claims of litigation. Advance, please. So to put that in perspective, I'm able to download and look at our claims profiles for the different industry segments we support. And so when I pull in, this is about the last 10 years of general liability. And I was able to narrow it down to, street and road, heavy highway, utility. And the point I'm trying to make here is when we look at all of the general liability claims that have occurred over that 10-year period for the industry sectors you all work in, look at the top one. It's the bodily injury claims. They're second as far as the total number of occurrences of a claim, but look at the dollar value. it's third-party bodily injury that drives almost 83% of all of the claim dollars. So I think that's important because this is the reality of what we're seeing. These are general liability claims. They're work zone related, and they often involve the traveling public. Next slide. So this is just an image, Doug spoke about this, Michael spoke about this, I believe everyone has, is depending on the contract, depending on the scope of the project, you're going to have a tower of insurance that's potentially available. And that tower of insurance is driven, by contract requirements. So you're typically going to see a 1 to 2 million, what we call the primary limit down there at the bottom. Before that, Whitney had spoken about, the nature of the industries. You may have a very large deductible that's in play prior to the insurance carrier even stepping in. And then really it goes from that $1 to $2 million first layer up through multiple millions of dollars. And again, that's dictated by contract requirements. The reason I'm saying this is when we're talking bodily injury claims, again, a $6 million claim is big, but they've exceeded 50. They've exceeded more than $50 million. So this is how impactful one of these events can be. Next slide, please. So I've used this image for years. I'm not going to take credit for it. It came out of an article from the Big Dig that happened in Boston years ago. And there was a ceiling tile that fell from the tunnel, and a woman was driving through the tunnel. The ceiling tile hit that vehicle and she was killed. What this diagram is, it kind of shows you what happens behind the scenes with everything that the panelists have talked about so far. This lists every entity that was involved in that situation, in that project, and every one of these lines is litigation to and from and back and forth between these entities. And the fact of the matter here is this is when we find out that there's been a breakdown. There's been a breakdown in either the insurance coming into play like it should. There's been a breakdown in what you thought or didn't realize you accepted from an indemnification, from an additional insured standpoint. So every serious event is going to look like this, and every line involves attorneys, it involves contracts, it involves scope of work, it involves everything that every panelist has just spoken about. Next slide. And why is that so important? Again, this has been mentioned a few times. I just want to re-level set us. We're talking about one of the most expensive costs that a company like yours is going to deal with, and that's insurance. And to break down insurance and the premium you pay and the rates that are associated with that premium, it really comes down to these three items. First of all, you can't control much about this. It's what you do for a living. What is the classification of work that you do? What's the scope of your work? There's rates that are applied to that type of work. So what do you do for a living? The second one is how much of that work do you do? So that rate is going to be applied to your different, what we call exposure basis. So there's going to be a rate based on the revenue. There's going to be a rate based on the payroll classifications. There's going to be a rate based on the number of power units you have from a fleet standpoint. So that's really the basis of where your premium comes from. The third one is the one that you have potentially the most control over, and it's the one that you really need to focus on, which is the whole intent of this presentation. When we go to look at a prospective contractor, we're going to look heavily at the claims history. Generally speaking, you're looking at least 5 years of claim history, if not 10 years, depending on the size and scope and nature of that contractor. The carrier is going to look very closely at severity losses. Again, going back to that $6 million claim, the ones where that tower of liability, you erode and break through each one of those layers. The frequency of severity losses is going to ultimately give you a very bad answer when it comes to your premium and your rates. And again, I'm hammering that point home because we've got to manage our claims. We've got to prevent them. When they do happen, we've got to mitigate them, and we have to minimize them because they're going to stick with you for a while. Something that happened yesterday is going to be in your claim record for up to 10 years when you go to look at another insurance carrier. Next slide, please. So just to wrap things up and kind of just put it all in perspective, this is real. This happens every day. We see these events happen. The panelists on this webinar see these events happen. And I just want to go, everyone's got to go way upstream. And everything we've talked about starts with the contract. Yes, you're estimating. Yes, you're looking at a lot of logistical items, but what you execute in a contract is where we really need to start. And again, reiterating, tap into your resources, your agent, your broker, your insurance carrier. It's the best situation for you and your carrier to not have a claim. And so tap into your insurance carrier, have them partner with you and your broker, have us work through this stuff so that we can prevent, but then also minimize a bad claim. We've covered indemnity and insurance. And again, I got to reiterate the point that's been made. Mary Beth made this very clearly, your scope of work. If your scope of work is not well defined and there is scope creep, especially when you're dealing with the traveling public, it could be a very simple creep of that scope that ultimately results in millions of dollars of loss. So those are my final thoughts. Todd, thank you so much.
Greg, thank you so much. I told you everybody that when he talks or something to listen to, and I thought you did a great job, Greg, at helping us understand the issue. So I hope that helps define the problem and give you some tools, techniques, and ideas to solve the problem. I want to thank the panel. It's hard enough for one person not to speak for an hour. We had 7 people speak, if you think about it, and I did it in 46 minutes. So I want to congratulate the panel and thank you for your time. It's hard, as my father once said, I'm sorry, I didn't have I couldn't write you a short letter. I didn't have enough time, so it's hard to write a short letter. It takes time to do it well, and you guys did a great job. So I want to open it up for questions. If anybody has any questions, Don, are we able to see them in the chat area?
Yeah, we should be able to see them in the Q&A, Todd.
Okay. I'm looking in chat, so I'm not sure I'm looking in the right spot. But in the meanwhile, while we're waiting for that, I would like to ask the group. I have a question for you. What do you do when the prime says they just won't negotiate? Like, just take it or leave it. This is the contract. I mean, this is not uncommon that the prime contractor says we're not asking you, about for questions. This is or issues. This is the contract. What do you guys think? What do you do when that happens? I do have the questions open now. Thank you.
I'm happy to take a stab at that for you, Todd. Essentially, what you have to decide is, you have to make a business decision and say, how much is the risk of loss in this situation versus the revenue that you're going to derive from the contract. So as probably everybody knows, a $5,000 contract can result in a $10 million loss. So like we keep talking about the scope. So let's say your customer, your contractor isn't going to be negotiable. Typically what you want to say is, okay, you might not want to play with the language, but I need to make sure the insurance endorsements you're asking for are actually included in my policy. And if they're not, here's what I can offer you. Remember, you cannot offer to your customers insurance which you don't have. So that's step number 1. Step number 2, I would say, is scope. Make sure there's no scope creep. Make sure your scope is clearly defined, including any inclusions and exclusions. And then number 3, like I said before, you as a business owner have to make a decision as to whether or not the risk, your cost benefit analysis, whether it makes sense for you to assume the risk.
Perfect. Thank you, Whitney. Anybody else want to follow up to that question?
Todd, if I could just add something. I've used the approach that this is not fair what you're asking. And people on the prime contractor side, I've rarely come across anybody who said, take it or leave it. They will talk with you. They'll be willing to make things fair. So I use that fair word a lot when I'm negotiating.
Yeah.
And again, there are times when it's like, you know what, maybe we just don't want this job. Thank you. Maybe we'll work for you on the next job.
Perfect.
Hey, yeah, that's all good points. I like to use everything that's available to us. So if you go through the whole contract, you may find the use of some antiquated terms, some inconsistencies, anything that you can use to get the attention of the person that you're negotiating with. So if you can get them to focus on a few of the pieces that, it need to be changed, maybe you can use that momentum to roll it into making some of the changes that are more favorable on the indemnification.
Perfect. Thank you, Mike. So there's a question here. Let me read it to you. It says, if a project is set up within state specs, let's say it's the Texas Department of Transportation, is there any way to get out of suits if the department comes in and says, were operating correctly and third party drove through a properly performed work zone?
Hey, Todd, I'll jump in on that one.
Thank you.
This is a tough one. I'm going to say that, you know, the sad fact is that every case is going to be determined on the facts. It's going to be determined on the merits of the situation. However, I think where this question is going, there's two states, Texas and Florida in particular, that have actually initiated legislation years ago. It's basically designed to protect the parties from liability if, I'm going to paraphrase, if at the time of the event, they are shown to be in compliance with this plan specifications, It's good language. I wish more states had it. However, I will tell you the facts of the case make it very challenging sometimes, especially if there is a serious injury or fatality event, for the contractor to be able to go, I'm in compliance, I'm out. And Whitney probably has some comments on this as well. But I guess the one thing I want to say there is, you know, and again, this kind of crosses into the work zone liability topic, is you need to do everything you can to show that you are in compliance. You need to do everything you can to have documentation to show that, because these events happen all the time. You could have a driver that is under the influence, is found to be on their phone texting at the time of an event, and there's been multi-million-dollar claims paid where you would think this isn't possible. So again, it crosses a little bit out of the contractual into kind of the legislative and the jurisdictional issues, but I think that's maybe where that's going. You've got to do the best you can to be in compliance with the specifications, the traffic control plans and everything like that, but it's going to get tested, and you'll find out how good you're doing when you get tested. Whitney, was that a fair way to kind of explain that?
Yeah, I mean, I have a little more cynical view of it. When I look at that, I think that complying with what TxDOT wanted you to comply with is a question of fact. So I haven't seen in any of those states, I haven't seen anyone get out on summary judgment in that type of argument, because the court's going to go, okay, well, it's TxDOT's opinion that you were in compliance with the specs, right? But were you is a question of fact. So like you said, Greg, the best thing you can do is have your evidence that you are in compliant. You know, I know a lot of contractors videotape their work zones, photograph them, striping, et cetera, et cetera. The more evidence you have that you are in compliance with the specs, the better. And if you can produce evidence that TxDOT approved of your work zone and you did everything you were supposed to do, that's going to sit very favorably with the jury, but I don't think it's going to get you, it's not going to get you a ticket out right away.
Perfect. All right, I have two other questions here. One is this is a question for Greg. In regards to his comments about partnering with insurance providers, should subs be sending all contracts to insurance before signing them? Might be a question for Mike too.
Yeah, I was going to say, Mike and I are probably maybe on the same page on that one. I would say, you know, your carrier, you know, I'll tell you where we get involved. I like to work with the contractor personnel to educate in conjunction with your agent broker, so that there's more people on the contractor side that recognize what to look for. You can't necessarily send every document in for another person to review. So the more you can catch red flags in advance, the better. However, you're going to have situations, and again, Michael, I'll let you speak, you know, from your standpoint, where you're going to have other parties that can help you look through that. And that is really something that a lot of your, you know, agents and brokers are going to do. And so, Michael, I'll let you jump in there.
Right. Yeah. The broker is your first line, you know, working directly with the broker to analyze the contract and review the risk transfer. But you know, you can also get some assistance from, you know, everybody works together. You know, it's the broker, the underwriter, the client. You know, these things are collaborative efforts. And you know, I think everybody can help. We don't send all of the contracts directly to the insurance company, but there are certainly times when we're looking at something, and you know, it might be questionable that it makes its way to the underwriter for certain.
Just to piggyback off that, Michael, I think you can say that it would be a good thing for your insurance broker to be your best friend. I communicate with ours on a daily basis. A lot of times your insurance broker can provide you with a breakdown that'll show you what endorsements you carry and what level of coverage those provide to an additional insured. A lot of insurance brokers also produce their own webinars and have other materials to help educate you not only about your policy, but about the limits of your insurance, the endorsements, and what different things mean, because insurance is hard. And going to the industry experts, your brokers is really helpful. Getting through the actual insurers is really tough, but going through your brokers is a great tool.
Yep. So I've got one more question. If we could answer this in a couple of minutes, it'd be great because we need a couple of minutes to wrap up. But it's regarding the additional insured endorsement, naming them prime instead of a blanket additional insured endorsement. Any additional risk in one over the others? Mike, do you want to take that, or I don't know if
Sure, I can start that one off. There are different editions. There's different edition dates, different versions, and there certainly are risks that most folks don't consider from one to the next. In particular, when you're trying to have that additional insured protection travel upstream, there's been a number of developments in a variety of jurisdictions that were basically the effect of the additional insured endorsement just is not what everybody anticipated. So again, if it's all about the language in the contract nowadays, it's all about the language in the additional insured endorsements, and some contracts try to sidestep some of the developments that have come down. But yeah, absolutely. I mean, 100%, you have to pay attention to the difference in the language, because if it's an undesired effect, then you're probably staring down the barrel of an indemnification provision.
Great.
That's a really, really deep question. I tried to just, do that as best as I could without getting into the trenches. But, I mean, that's a long conversation. I've certainly and happily have that offline.
Okay, thank you. All right, so there are some documents that Donna wants me to let you know are in the chat. There's the PowerPoints there and level in the playing field document, as well as a legal liability handout. In addition to that, I would like to let you know, as we wrap up, that there's going to be an ATSSA conference, which all of us will be at here, February 19th to the 21st in Phoenix, Arizona. We are going to be having another session on indemnity contract review 101 on Sunday, February 19th from 9:15 to 10:15. So please, if you're there, come see us. We'd love to finish this. Maybe a way to finish this conversation, Mike, around the named insured. I also just wanted to thank the board, the panel here for coming. There's a lot of work that went into doing this, and a tremendous amount of tightening up the conversation in order to have a 1-hour conversation on this very important topic. So thank you so much. There is a survey, I understand, at the end of this that we would like everybody to take, and so we can find out how we did and we can do better at the next session. And Donna, you wanted to mention there is a in the safety requirements that are in the contract, holding, you want to be able to hold the same, I think, Donna, if I'm saying this correctly, that you want to make sure they know they're being held to the same standard as the prime, and that we need to be aware of that, right?
That actually came from one of the attendees.
Oh, came from one of the attendees. Okay, great. Okay. And is there anything else, Donna, that you want to say before we wrap up?
No, that's it. I just, thank all of you, Todd and all of the presenters. You did a great job. This is really good information for our members, and I know that they're going to find it valuable. I encourage you all to attend the workshop session that they're going to be doing at the expo. You're going to get more good information, and please stick around for just a second to fill out the evaluation. Michael is going to pop it up on the screen here shortly, but thank you all.
Thank you, everybody. Bye-bye.